Assalamu alaikum. This is the second lecture of Contract Act, and in this lecture, we will learn about the concept of enforceability and essentials of a valid contract. In the first video, we've already learned about what is actually proposal and how it converted into promise, and eventually, the next step will be agreement and how agreement can be called as a contract if it is enforceable by law. So what is actually enforceability and what are the essentials of a valid contract? We will learn deeply in this video. So let's start this video. First of all, the enforceability. Every contract is an agreement, but every agreement is not always a contract. This is a statement which I told you people in the first video that every contract is an agreement, but every agreement is not a contract because all agreements are not enforceable by a law. If all agreements are enforceable by a law, any agreement enforceable by a law, then it can be called as a contract. But in other case, if it is not enforceable by a law, then it is not a valid contract, or it is not a contract even. It is only an agreement. So an agreement creating a legal obligation say to be enforceable by law, the parties to an agreement must be bound to perform their promises in case of default by either of them, must intend to sue. For an agreement to be enforceable by law, there should be legal obligation instead of social, moral, or religious obligations. So it is very clear that the legal obligations between the two parties are due to their mutual are due to their um, promise which they have done before. So if they will not perform their legal obligations or any one of them are not perform their legal obligation, then the other party should sue them in the court. But it can only be possible if the contract is enforceable by law. If it is enforceable by law, then you may proceed towards court in case in case of default or misrepresentation or fraud or by any means of non-performance of the other party. So enforceability is very important. If there is no enforceability, then it is not a contract. It is simple an agreement between the two people, and there is no legal standing in the according to the Contract Act and according to the law. So let's move to the essentials of a valid contract. If there is a contract, then these essentials should be present. If any of the essential is not present, then there will be a question that whether these contracts are valid or not. So first one is the offer and acceptance. As we know that there should be at least more than one party, and one party has proposed the other party or give offer to the other party, and if the party which receive the proposal from the first party accept, then it become a promise or agreement, and if enforceable by law or contract. So the first essential of any contract is this: there should be an offer, and there should be an acceptance of that offer from the promisee. Legal relationship, as I already told you, there should be a legal relationship between these two parties. There should not be according to the religious or moral values, and legal relationship means it should be in writing. Okay, if you're gonna sue someone in court, then you should present any evidence that there's a contract. So legal relationship is something very important. If there is no legal relationship, then it will not be a valid contract. And the third one is a competency of parties. So as per section 11, the parties to an agreement must be competent to contract. In other words, the person must be of age of majority, person of sound mind, and not declares disqualified from contracting by any law to which he is subject. Now the question is, what is the age of majority? Age of majority, according to the Contract Act, if the party has a is under is living under the parents, then the age of majority is 18. If parents are not alive, separated, and if that person um, brought up under the custodian is not parents, is actually a guardian other than a parents, then the age of majority is 21 years. So if any one contract with any person which is under the age of 18, then contract is not valid because the person is not major, the other person is a minor. In case if his age is 20 but his parents are not alive and he is under the custodian of guardian, is still minor, he is not major, and the contract is not valid. It is a void contract. Person of sound mind, person of sound mind actually means he should have a rational decision power. He is capable of taking those decisions which is beneficial for him. And if he will come to in any contract, then he knows he will get a profit out of it. He will not he will not bind himself in any contract where he will bear loss, and it is under his knowledge. And third one, according to any law, must not be disqualified. He must not be solvent or criminal. So this is the competency of parties. These all 3 points should be present in all parties of the contract. D is a consideration. I've already described consideration in the first video, that if someone if there are two parties and there's a contract, then there should be a consideration for the both parties. If Mr. A deliver 5,000 goods to Mr. B upon rupees 1 lakh, then the 5,000 goods is a consideration for Mr. B, and Mr. B will pay 1 lakh rupees to Mr. A. So 1 lakh is the consideration of Mr. A. So consideration should be uh, present in the contract. Here, if you have gratuitous promises which have no consideration, are not enforceable at law. Okay. Now, next is free consent. So, as per Section 14, an agreement must be made between parties by free consent. Like, if you propose someone, then you will obtain the consent of other person freely. There should be a free consent. That consent does not obtain by means of coercion, undue influence, fraud, misrepresentation, and mistake. What is actually coercion or undue influence? Coercion is something different. If you threat someone, or if you send gangsters to the person to whom you propose, to threat him to accept your offer, it is actually coercion. Undue influence is actually, if you are a manager and you have a subordinate and you want to you propose something to your subordinate in order to make a contract, and you are using your superior position that you are a manager of that person, then it is an undue influence. Similarly, if there's a teacher and teacher want a commercial contract with his or her student, and by the student knows that the teacher may give me bad grades if I will not accept his offer, then it is also undue influence. So you will not get the consent by means of undue influence. if you if you propose someone and conceal something, you do not want to you give a wrong information to the other person and the other person has accepted your offer, then this is a fraud or somehow misrepresentation. So again, this is not a free consent, or there's a mistake, there's a bilateral mistake or mistake, and we will learn about these terminologies in our next videos very deeply. So if in short, if the promisee give you consent by means of by exercising by exercising of these act by the promiser, like caution, undue influence, fraud, misrepresentation, mistake, then the contract will not be valid. Lawful object, there should be a lawful object. In short, there should be a lawful consideration. Okay. There should be the consideration will not be forbidden by law, or it does not it does not mean of that nature which actually defeat the provision of any law. It is not fraudulent, and it does never involves an injury to the person or property of another, and never supposed to be immoral or opposed to the public policy. Like if you give money to someone, and you want him to kill your cousin because you hate him, you are jealous of him, or um, or due to any reason, so this is not a valid contract because your intention is to injure someone or to get a life of someone. So this is immoral, opposed to the public policy, or opposed, it's actually involves the injury to the any other person. So the lawful, it is unlawful object. The contract is not valid in this case too. Non-declared as void contract. So as per section 24 to 30, an agreement which is not enforceable by law is called void agreement. Okay. There are certain agreements which have been expressly declared as void. Okay. These are the agreements which are void agreements. Void agreement means they are not legal contracts. They are not enforceable by the law. So these can be called as a void agreement. So first agreement, which is partially unlawful, you give 5 lakh rupees to someone and ask him to deliver you rice of half amount and drugs of the remaining amount. Then the partial consideration is unlawful. So the whole contract is void. Agreement is void. This is not a contract because there is a unlawful object and it is not enforceable by law. The second one is agreement made without consideration. If you give someone money and that person is not giving you something, then it is also void agreement. If you refrain someone from doing marriage or legal proceeding or trade, then it is also a void agreement. You never restrict someone in order to trade with someone or to get married with someone or legal proceeding against someone. It is a void agreement. Uncertain agreements and wagering agreements. Uncertain agreement. These are the agreements which are actually um, contingent, or you can say linked with uh, any event which is uncertain. Like you said that you will give rupees 5 lakh to someone if sun will rise from the west. So this is uncertain agreement. This is a void agreement. Now, G is certainty. The agreement may be void on the grounds of uncertainty. The meaning of agreement must be certain or capable of being certain. Like Mr. A has three type of goods: quality A, quality B, and quality C. You offer Mr. A to deliver 5,000 goods. Now, what type of goods you want him to deliver you? This is the question. So here is uncertainty. So this is a void agreement until unless you will make him certain or clear that what type of goods you actually want. Possibility of performance as per section 56, the term of the agreement must be capable of being performed. An agreement to do an act impossible in itself is void. You promise someone that you will bring moon in a return of rupees 6 million. This is impossible. You can't do that. Okay. You said that you will any impossible act you can be counted as the according to section 56 is void agreement. Now the legal formalities as per section 25, an oral contract is a perfectly valid contract except in certain cases where a contract must comply with the necessary formalities as to writing, registration, etc. So oral contract are also valid contract, but in some cases you there should be a proper paperwork. As I said before, if you're gonna sue, then you must have some evidence in order to present the court that look, we had a contract and he's not performing his performance, that's why I'm coming here to sue him. So you should have a contract here. So these are the essentials of contract, and all essentials should be present in the contract in order to make him a valid contract. Otherwise, it will not be a valid contract. It will be counted as a void agreement. Thank you so much. Allah Hafiz.